And Dr. Joe, feel free to take it away when you're ready.
All right, thanks, Shakima. Good morning, everyone. Thank you for joining us at our first live member-only briefing. And I just wanted to thank you for coming to our inaugural briefing. This is a labor of love from our board, from Philly Sherm, as well as myself. And I'll introduce myself. My name is Dr. Joanna Vasquez, but everybody calls me Dr. Joe, and I'm the president of Philly Sherm. And again, I want to welcome you to this member briefing. And just kind of like a little bit of an overview. These briefings are to provide a timely information and insights to the social, economic, political, and legal developments shaping our region. But it's also a way for us to support HR professionals and of course members of our affiliates, not just within Philly Sherm, but with also our local partners. And I want to give a shout out to our local partners, and that would be Tri-State HRMA, Sherm Berks County, and of course, Greater Valley Human Resources Association. So, and these briefings are to help our members to respond to changes and challenges strategically. And we are also wanting to make sure that if you know someone who is not a member, until December 31st, we have an exclusive in terms of membership. It's like a $200 value. You get 50% off SHRM national membership, and we waive our local membership, which is again a deal that I have never seen. And it's a great way to, for those who are kind of on the fence because of cost, to come in and be part of SHRM National and then Philly SHRM. We are a dual membership, so you have to join national in order to join the local. So please take advantage of this particular offer. And then before we get started, just to kind of give you a reminder, these briefings are one in our arsenal of giving you information. We have our virtual events as well as our in-person events, but we also have a podcast called HR Fresh Take. And we're leaving this up for a few seconds if you want to actually scan the QR code to go and listen to the latest episode on neurodiversity in the workplace. And also, you can access it on your favorite podcast platform by searching HR Fresh Take, and this is our logo. So, with that being said, and again, this is a briefing, we want to get started right away. I am happy and it's my great pleasure to introduce Michael Cohen. And he is the partner of in Dwayne Morris's Employment, Labor, Benefits, and Immigration Practice Group, and a good friend of Philly Sherm and to myself. And I am very happy that he has been so gracious to begin our briefings. And I'll send it to you, Michael.
Thanks, Dr. Joe. Before we get started, let me just make sure everybody can see. Can we see my deck okay?
Not
Shakima,
yet.
Dr. Joe, we're good?
Not yet. I don't see it.
Hold on, let me try something
No.
else. Please. Now.
Yes. Yeah.
Perfect. All right, folks. Dr. Joe, thank you so much. And let me just do a really quick another plug for HR Fresh Take. It really is an incredibly powerful source of content and of information for all of us in the Philadelphia area, in Pennsylvania, in the tri-state area, with really some insightful guests, thoughtful guests who provide meaningful and practical takeaways just about every week. It really, it's mandatory listening. So Dr. Joe, thanks for all you do on that. So my name is Mike Cohen. I'm a lawyer with a law firm called Dwayne Morris. I'm based in the great city of Philadelphia. 1-0 for those of you keeping score at home for our Philadelphia 76ers. I'm pretty sure the season will end 82-0. So I'm pretty psyched. Thank you so much for giving me the opportunity to have a conversation with you all today. And I suspect as HR professionals, we all have seen the level of attention paid recently to things like harassment, to things like discrimination and retaliation, whether it is as a result of executive orders, whether it is as the result of Department of Justice activity, whether it is the result of the Equal Employment Opportunity Commission's announcements and proclamations and new emphasis, and what that has resulted in directly, and we are seeing it right now playing out in real time. There was no lag. What we are seeing right now playing out in real time is a massive increase in internal complaints of harassment, of discrimination, of retaliation. And as HR professionals, we had best be ready for when these complaints come. So, what we talked about having a conversation about this morning is about internal EEO investigations and the nuts and bolts, how we get ready for it at a reasonably high level, what kinds of questions we should be asking, what kinds of labels we should and should not be using, what the decision-making process ultimately ought to look like. Anytime I facilitate a program of this nature, I certainly would invite questions. Dr. Joe Shakima, if you see questions in the chat, please by all means interrupt me. If there are questions and we don't get an opportunity to answer them, you see on the screen right now my contact information. By all means, please do not hesitate to reach out to me. So first question that comes up all the time, a complaint comes or we receive information in some form about inappropriate conduct. The first question is whether we even have to conduct an investigation. And as HR professionals, we know there's probably no phrase more incorrectly used than I'm being subjected to a hostile work environment or I'm being harassed. The reality is those phrases very often don't mean what people think they mean. And there is a certain amount of, pardon my language, crap with which employees have to deal on a day-to-day basis that does not implicate our obligation to conduct an investigation. But let's go through 7 or 8 different situations where that obligation absolutely is implicated. And the first, of course, is when an employee brings to us directly a complaint of harassment, of discrimination, of retaliation. When we get a complaint of this nature legally, we have an obligation to conduct an investigation. When a manager or a supervisor complies with what are their crystal clear legal obligations and reports to us the existence of some kind of a complaint made to him or to her or to them by an employee. And folks, it is crucial that our managers understand what I just said. And that is they have an absolute legal obligation to report to human resources all complaints of harassment, discrimination, retaliation, inappropriate conduct based on somebody's membership in a protected class. Even if an employee says to them, I'm just telling you as a friend, I don't want you to do anything about it. I need you to keep this off the record. Off the record is not a thing. None of us is a reporter. We have legal obligations under those circumstances. Where an employee reports to us a complaint that they received from a coworker, and what people often refer to this is as well, it's hearsay. Well, first of all, it's not hearsay. Hearsay is an out-of-court statement made for the truth of the matter asserted. Stop calling things hearsay. It may be secondhand, it may be third hand, but my question in a situation like this is, why would we not investigate? Why would we not look into allegations, even if we do not receive them firsthand? So if we get a complaint from an employee based on a complaint from another employee, what's the worst case scenario? We do nothing and we find out there actually was a complaint. Alternatively, we go back to that employee, we start asking questions. It turns out there is no complaint. Fine, we've done our job. Fourth, where there's an anonymous complaint capable of investigation. A lot of organizations have internal hotlines, or an employee is clever enough to send an email or a message of some kind without identifying themselves. Question that I always ask first and foremost is the anonymous complaint capable of being investigated? Do we have enough information based on the complaint where the identity of the complainant kind of doesn't matter? For example, and this is just one example, for example, An employee raises a complaint based on conduct that occurred at a public meeting, at a department meeting, at a team meeting, at some kind of forum your organization is holding or having. Holiday parties are coming. We all know that they're coming. And she came in, Dr. Joe and I were talking about this before we started this webinar, which is sort of the irrational at times emphasis on alcohol at these kinds of events. And while I joke, holiday parties keep me busy from January to May, it's not completely a joke. So were something inappropriate to occur, for example, at a holiday party, there in all likelihood will be enough people around. It occurred at a public enough event that we will be able to conduct the investigation, notwithstanding the fact that the complaint was made anonymously. On an employee's way out the door, constructive discharge allegations. Yes, I resigned, but the reason I resigned is because my manager has subjected me to a hostile work environment based on my religious beliefs for the last 6 months. Capable of investigation? Absolutely. Well, even though the person has resigned and this is the person's last day, we still have the investigation obligation. Complaint upon termination. Yes, you fired me, but you fired me because I raised a prior complaint. What do we have now? We have a complaint of retaliation, which we are duty bound to investigate. If an employee files a complaint with an administrative agency, even if they have not filed the complaint internally while they worked for us, we still have this investigation obligation. So these are just some of the situations during which an investigation is required. Now, what happens, as I mentioned earlier, when an employee comes to your manager, or in this situation comes to you and says, here's the complaint, but I don't want you to do anything about it. These are my privacy rights. There are no privacy rights here. I don't want you to do anything about it. Do we have a duty still to investigate if the employee basically demands that we not investigate? And there's a dichotomy here. And I think the first set of questions deals with, has there been a tangible adverse employment action? So the employee complains that his, her, their termination, his, her, their demotion, his, her, their failure to promote or failure to receive a bonus was as a result of their membership in a protected class. Seems to me pretty clearly in situations like that, we have the duty to investigate. We don't have a choice under circumstances like that, because if there has been something as permanent as, for example, a termination, we have to investigate. So even if they tell us they don't want us to, where there has been a tangible adverse employment action, this duty is pretty real. Now, in those situations where it has been an environmental allegation and an allegation of a hostile working environment, for example, for me, the presumption still always is in favor of conducting the investigation. But if we are contemplating, for a myriad of reasons, not conducting that investigation, there are a number of factors, and these are not certainly all of the factors, but there are a number of factors that we want to include in determining whether we should be conducting the investigation. The first two is, how severe was the behavior and how pervasive was the behavior underlying the complaint? Why are these the first two? Because we all know, in order to prove a hostile work environment under the law, the conduct must be severe and pervasive. So the more severe, the more pervasive the conduct, the more it weighs in favor of our conducting the investigation. Have others also been impacted? Have there been prior complaints, either by this employee or about or against the same employee about whom the allegations have been raised? What are the positions of the parties? The greater the differential in positions, the more likely it is we must investigate. These are just some of the factors, some of the criteria we are going to consider in making that determination about whether we will in fact conduct the investigation based on a hostile work environment where the employee requests or even demands that we don't investigate. If we make the decision not to investigate, I think there are a few follow-up steps we have to consider taking. Number one, we need to create a document outlining the basis for not conducting the investigation, which of course will start with the employee's demand that we not do so. That we went back and we discussed with the employee the fact that we have the obligation, that we told the employee not only are we willing to conduct the investigation, but we very much want to conduct the investigation. And for whatever the factors happen to be, the decision is made not to conduct the investigation, again, at the employee's request and or demand. And that's not just an internal document. That is a document that we are going to provide to the employee himself, herself, themselves. And honestly, I want the employee to sign it. I also want to make clear in that memo that should at any point the employee change their mind and now wants us to conduct the investigation, all they have to do is let us know and we will start the investigation immediately. I want to make sure, even though I provide that invitation in the memo, that I continue to follow up affirmatively with the employee, making sure that they have not changed their mind. And of course, given the fact that I have a certain amount of information, a certain type of information, I've got to make sure I continue to observe the behaviors, the conduct that are taking place. So we've made the decision that we're going to investigate. Now we got to figure out who's going to do it. And the default position typically is in all likelihood is going to be us as human resources. But there are certain situations which in all likelihood will prevent us as HR, as those who typically will conduct the investigation, from actually conducting the investigation. For example, if there is an actual or a potential or even a perceived conflict of interest, we need to make sure that this investigation not only is prompt and thorough, it has to be fair. And even the perceived conflict can impact on that fairness. If you have a personal relationship with the parties involved in this investigation, you probably cannot conduct it. Obviously, if you are a necessary witness to the investigation, to the allegations, you attended meetings where there was alleged discriminatory or harassing conduct, you were a decision maker based on the discriminatory act, you can't conduct the investigation. You can't be investigator and witness at the same time. Or just based on the allegations, for whatever reason, you don't perceive that yourself, you don't think that you yourself can actually be objective. So if there is this conflict based on personal relationship you have with either party, if there is the potential for you to be a necessary witness, or if you don't think for whatever reason you can be objective, we've got to look for another alternative, someone else who potentially can conduct this investigation. Another situation where you may not be able to do it is if the allegations are so serious or they involve a senior officer or a senior leader inside of your organization where you may, and I mean nothing disparaging by this, you just may not have the juice to be able to conduct the investigation into allegations raised against your CEO or raised against your chair of the board. You may need to, or certainly want to, seek an outside party, whether it's an HR consultant, whether it is outside counsel. Under circumstances like this, we may want to look externally. So but again, in the lion's share of the time, we as HR are going to be the person where we're going to conducting the investigation. And our role as investigator is, while we are a representative of management in this kind of a situation, we are here as a neutral finder of fact. And that needs to be made clear to the employee, to all of the people involved. You do not have a stake in this. You've got no dog in this fight. You are a neutral finder of fact. We are not there to advocate on behalf of anyone or any position or view. I know Dr. Joe talks an awful lot about maintaining the human in human resources. And that doesn't deviate during the course of our investigation. Empathy matters. We want to be neutral, but we want to maintain some level of empathy and kindness throughout the course of the investigation. We're going to take every allegation, every complaint very, very seriously, and we need to demonstrate objectivity. One thing that I still see all the time, unfortunately, when I review investigation reports that organizations create based on an investigation, I still see conclusory labels. And what I mean by that is referring to the person who raised the complaint as the victim. Well, victim implies that there's been wrongdoing. We don't know that there's been wrongdoing. They're not the victim, they're the complainant. They're the person who raised the allegations. Similarly, referring to the person about whom the complaint is raised as the harasser. No, they're the person about whom the complaint was raised. They are the accused. Using phrases when reaching conclusions in an investigation report, like we have made the decision, we have made the determination based on all of the facts we have uncovered that there has been harassment. There has been the creation of a hostile work environment. There has been discrimination or retaliation. For the love of all that's holy, don't say that in a report. You're not making legal determinations when you conclude an investigation. And when you say there's been harassment, the manager created a hostile work environment, there's been discrimination or retaliation, you've just created potentially a binding legal admission against your own organization. That's not what the findings say. The findings are about conduct, the findings are about policy violation. We don't make findings with regard to legal conclusions. Obviously, timeliness is crucial. Prompt and thorough and fair. Implicit in prompt and thorough and fair is that you're not just sitting around. We need to commence the investigation as soon as is possible. That doesn't always mean within 48 hours. There may be external factors preventing you from starting the investigation as quickly as you would like, but we got to get it started. And once we get it started, we got to get it done as quickly as we can. The questions we're asking during the course of the investigation, I view as typically it's a funnel. We start very broad and then we narrow and we narrow and we narrow and we become progressively more targeted. We ask non-leading, open-ended questions. Ultimately, we may have to get to that question at the base of the funnel that is very specific. It is the "did you do it" question, but we start open-ended and we narrow and we narrow and we narrow. Make sure that as soon as you get these allegations, we start forming the schedule. I actually have these slides out of order. I'm not sure why I'm talking about questions before we have a schedule. I apologize. But typically the complainant is going to be the first investigation or the first interview. And then the default position, far too frequently for my liking anyway, is the next person we're going to talk to is going to be the accused. That's not always the case. We're at a decision point now. After we interview the complainant, we need to take a step back and determine, based on the information that we have gleaned from the complainant, does it make more sense to interview more witnesses, or does it make more sense at this point to interview the accused? When we make the decision about the investigation, there are a few different ways we can go with the decision. One, that the inappropriate conduct occurred and it was that the allegation occurred and it was inappropriate. Obviously going to have to be action. That the allegation occurred, yes, but there was nothing inappropriate about it. Probably not action that necessarily needs to be taken. It didn't occur, or I'm not sure whether it occurred. These typically are the kinds of conclusions that we're going to make. We talked about avoiding legal labels when making our decisions. But one of the things that I think investigators, HR professionals very often shy away from during the course of their drafting their investigation report or in making findings is credibility. And I think credibility is incredibly important. And there are a number of factors we may want to look to in making credibility determinations. How consistent has the person been? Has there been lying? Has there been an inconsistency in their stories? What does their body language look like? Why did they wait so long to raise the complaint? Why did the complaint only come following their being given a final written warning? Have others corroborated, or have others said, not only did I not see that, that sounds wildly inconsistent with the way the accused normally conducts themselves? These are just some of the factors we're going to consider in making credibility determinations. And ultimately, we get to the end and we need to figure out what kind of, if any, corrective action is going to be taken against the employee. Typically, if there's been inappropriate conduct, a verbal warning very rarely is enough. If there's been wrongful, if there's been inappropriate behavior that violates our policy, typically a verbal warning is not going to be enough. At a minimum, we're looking at some kind of formal disciplinary warning, if not a final warning, potentially some kind of a financial penalty, of course, at all times, if it is an exempt employee paying attention to the Fair Labor Standards Act. Very often, we may need group training. We may need one-on-one training with the wrongdoer, the person who is engaged in inappropriate conduct. And sometimes, not always, we have to fire somebody. Factors to consider in making the determination as to what the remedy is going to look like, how severe, how pervasive, were there prior issues with this employee? Again, how high level a person is this within your organization? Have they been responsive? Have they been helpful during the course of the investigation? And any other factors. All right, folks, I know that was incredibly fast moving. We're, as Dr. Joe said at the beginning, we're trying to create these opportunities for us to get a look at a subject that is topical. And like I said at the beginning, I'm not sure these days there's anything that we need to get our arms around more than making sure that when these internal complaints happen, and they are going to continue to happen, that we are ready to go from an investigation standpoint. Thank you all very much for your time. I know Dr. Joe, I know Shakima has some more information right now.
Thank you so much, Michael. You always you always have such great information and insights for us. So we really appreciate you. Just again, just want to thank our partners. If you came in late and you didn't see this slide, again, thank you to Tri-State HRMA, Sherman Berks County, and Greater Valley Forge Human Resources Administration for being a partner in our legal briefing. And just a couple of housekeeping, just please complete the post-event survey. And then if you want certification credits, that will be sent to you 1 week after our event. And just so that you know, there's a question regarding recording. Again, this is a member-only benefit, so it will be available on the member portal on Philly SHRM's website for about a week. And then we have 2 upcoming briefings. The first one actually is the economic outlook with a focus. It's a national economic outlook with a focus on AI exposure locally. So that's going to be delivered by the Federal Reserve Bank, and that's going to be scheduled for December. So stay tuned for that. And then next is going to be in January, the State of Education that will be offered by Alvernia University, and it will be talking about education and the current workforce. So again, thank you so much for joining us, and I look forward to seeing all of you again for our December briefing. Thank you.